SJC-12730, in the matter of Gregory M. Olchowski.
Ms. Mulligan, good morning.
Good morning, Your Honors. I'm Maureen Mulligan. I represent the IOLTA Committee, and I'll be speaking on behalf of the appellants this morning. May it please the Court. The question before the Court today is what happens with unidentified IOLTA funds and who gets to control the disposition of those funds? The committee contends that this Court has the authority to do so because this Court established the IOLTA accounts and has the ultimate authority to regulate the practice of law. In that regard, this Court has the power to control the disposition of the unidentified funds. In prior bar proceedings before single justices of this Court, the Court has already issued a number of orders on petitions from lawyers, from commissioners appointed by the Court, and the Client Security Board to distribute unidentified funds to the IOLTA Committee.
Doesn't that seem like a wash? Because there are instances where this Court has ruled on unidentified funds, and then there are other instances when we don't know about it, and the BBO doesn't know about it, and the banks report, and it goes to the Treasury.
Well, the fact that the banks report IOLTA accounts to the Treasury, I think, has absolutely no bearing on how this issue should be resolved. Under the terms of the abandoned property statute, the banks are banks and other companies and other entities that hold funds that may be abandoned.
I guess on a grander scale, my question is more, past practice really shouldn't govern because they have a past practice and there's another past practice that doesn't really resolve the issue.
Well, there is a practice of this Court. I take your point, Your Honor. We think that it does impact the decision because the Court is clearly aware of the abandoned property statute, yet has issued orders.
Really? Or is it just that the Treasury Department hasn't sort of come forward until this case, and it was sort of uncontested what was being done before, and for once the Treasury Department got involved, intervened, and now we have the issue joined for really the first time. Isn't that really where we are?
I appreciate that that's where we are, Your Honor. Yeah. And although the Treasury claims that its governance of IOLTA accounts through the abandoned property statute has an incidental effect on the practice of law, or an incidental effect on the judiciary's control over the practice of law, that's really not the case. I mean, they're clearly in your lane in this regard.
On that score, do you still win if we don't accept your statutory interpretation argument?
I'm sorry, I couldn't hear that. Would
you
mind
still
repeating?
win? So suppose we don't accept your argument about whether or not this comes within the parameters, in a broad sense, of the abandoned property law. But we also have, as you started out with, our independent authority to regulate the practice of law. We set up IOLTA, we set up these mechanisms. So even if it comes within the purview of the statute, the money still can go to the committee.
Absolutely, Your Honor.
As a softball.
And I really appreciate that. But as you have so eloquently explained, the oversight of IOLTA funds by this Court is really critical to the protection of clients, attorney-client confidences, the ethical obligations of lawyers, and the maintenance of public trust in the practice of law. And what we have learned through the Treasury's brief...
Is it that much of a softball? Because I'm just wondering if he's put some spin on it, too. So let me take it one step further. Say it is covered by the statute, it's abandoned property, but it's somebody's property and it can be identified. This Court's never taken anyone else's principle, have we? I mean, I understand we take the interest and put it in the IOLTA account. We've never gone the next step and taken the actual amounts and put it in the IOLTA account, have we?
No. One of the problems with the way...
That seems a little different. So I'm a client of one of these lawyers. I've given you $1,000 and you didn't do the work, and I want it back now. And I actually am out there, and somebody can find me. Do our superintendent's powers empower us to take that money away from that person now?
Absolutely not, Your Honor. If the identity of the owner of the funds is known, then those funds should be returned to the person that gave them to the
But isn't the
lawyer.
Treasury saying, I can find that, I may be able to find that person, and I do it better than you do, IOLTA?
So the way the Treasury attempts to find people under their regulations and under their research, and it's stated very clearly in their brief that the way they attempt to find owners of IOLTA accounts is they look at attorney-client fee agreements and they look at attorney-client documents. And so what's happening here is that they are invading the attorney-client privilege, which is one of the most important parts of the attorney-client relationship. And what we have found, or what we now know through the affidavits that have been submitted to the court by the Treasury, is that not only is the Treasury doing this research, but they have hired a third-party vendor to manage the abandoned property accounts. And that third-party vendor has the opportunity to go in and look at attorney-client fee agreements and attorney-client documents in order to determine the owner. And so this is a problem because that is part of what this court regulates in terms of regulating the practice of law. And the Treasury's attempt to intrude on the attorney-client relationship, and frankly, the attorney discipline, if there's something going on where that's not just a negligent accounting, but there's some other type of misaccounting by a lawyer, that should be governed by the systems that have been set up by this court to look at the oversight of the practice of law.
But I'm confused, but again, I don't mean to be difficult, I just don't understand it. So the Treasury Department, you've got some of, the lawyer doesn't, the lawyer is given up, right? There's no attorney-client relationship anymore, there's no work being done, right? What we're dealing with is trying to give the money back, right? Is the attorney-client relationship still in a place at that point? Is there still a privilege for that? Client?
There's certain.
I mean, basically, you took my $1,000, you put it in the IOLTA account. I'm just trying to get a sense of whether this is really an attorney-client issue or is it just giving money back issue?
So in order to answer that, Your Honor, can I step back just a little bit?
I don't know the answer, I'm just
and
asking.
talk about the creation of IOLTA accounts. I'm sure the court's familiar, but just to make sure we're all on the same page. When an IOLTA account for an attorney is opened, the purpose of the IOLTA account is to deposit money that's going to be held by the lawyer or the law firm on a short-term basis. So in my IOLTA account, I might have funds from one client or I could have funds from 25 clients. And it's all pooled and it's all mixed in. And when the lawyer deposits that money with the bank has no idea whose money that is.
Aren't we just dealing with the merged accounts in this case? We're not dealing with the individual accounts, right? Because there would be a name on those.
Correct. We're just dealing with IOLTA accounts, which is different than a trust account in the name of an attorney, in the name of a client. So the IOLTA accounts.
Aren't we just dealing with the IOLTA accounts where you put together a bunch of people's money as opposed to, again, but maybe I'm misunderstanding.
That is the definition of an IOLTA account, Your Honor. An IOLTA account is a pooled account with multiple clients' funds in the account. And those are the accounts that we're talking about here today. Clearly, if an attorney has a client trust account, there's a client name on that account. The attorney would always know to whom that money belongs. But there's a very intricate method of accounting that attorneys are supposed to adhere to in order to keep a record of which client, or in fact, sometimes third party, for example, in a real estate closing, a bank might give money to a law firm that gets deposited into the IOLTA account. There's a very detailed system of accounting that the law firms are supposed to go to know whose money is in that pooled account, because the only person that has the information, or should have the information, as to whose money is deposited in that account is the lawyer. So when the Treasury says, in response to your question, don't they have better resources to find people? The way these IOLTA accounts are listed on the Treasury's gofindmoney.com website is they're listed as the IOLTA account of Jane Lawyer, for example. So they're not listed as Mary Smith's money, which is how other accounts are listed on the gofindmoney.com website. So there's no real way for an individual to say, oh, there's my money on that list.
But if an individual knew they had given money to an attorney and they see that, doesn't that tell them they should ask the registry?
Yes,
The
but what-
Treasury, I mean.
But what happens at that point is the Treasury then begins to look at attorney documents, at attorney-client agreements, at client documents.
Client is coming forward and asking them to do that, there's really no client-attorney issue.
Possibly, but I think that the client should not be forced to disclose issues that were formally confidential just to prove that there's money in
was
the
it-
account. Where if you
Can you compare for me how the Treasury would go about identifying somebody, which, well, I guess that's the publication, but who's responsible for the IOLTA account after the attorney's out of business?
When the attorney goes out of business, per order of this court, the IOLTA accounts are supposed to be closed.
Okay, who's supposed to close them, the lawyer?
The lawyer is supposed to close the IOLTA account.
So if the lawyer didn't close this IOLTA account, and the IOLTA account exists, why does not the Bar Discipline Agency, the Board of Bar Overseers, take care of it?
One of the processes that the Board of Bar Overseers has in place is that it appoints commissioners to look into identifying to whom the funds may belong in the IOLTA account. And in fact, this court has also appointed commissioners to do that same thing.
And in this case, it was impossible, right?
Correct. It was impossible to
The
figure.
investigator who looked at it, nobody could figure it out.
Correct. The lawyer's accountant looked at it and couldn't figure it out, and the Office of Bar Counsel's accountant looked at it and
In my
couldn't figure
memory
it
is,
out.
of the ones where the banks reported directly to the Treasury, there were some 58 instances where people had claimed their funds, correct?
Correct.
So we have to compare that to what happens with commissioners to see how successful commissioners are in returning unclaimed funds, right?
Well, it's not an apples-to-apples comparison, because what we don't know for the accounts that have been turned over to the Treasury is we don't know whether all of the monies in those accounts are actually unidentified funds. That information hasn't been provided. So it's possible that there's information either through the attorney that certain monies in those accounts can be identified. So we don't know that. We don't know if the Treasury has gone out and found 58 people whose money were in the IOLTA accounts and actually were not identified, or if people came forward, or if lawyers came forward and said, that's my account. I have not had any communications with the bank in X amount of time, but it's an active account. I haven't had reason to deposit any money in that account in the last 3 years.
And you argued it was an active account because of the fact that the interest was going to IOLTA anyway?
Certainly. So if we're looking at the statute itself, I think up until this point, we've been saying, if the statute applies, why should this court still have authority? And let me just wrap that up in one sentence. This court should have the authority because it has the authority to regulate the practice of law. But if you want to turn to the statute.
Yeah, I don't think, frankly, that's a great argument for you.
How is
statutory
it?
argument.
How is it principle going to the general fund interferes with the regulation of the practice of law?
It's not the principle going to the general fund that's interfering with the practice of law. It's the method by which the treasurer is attempting to reunite the owners of the funds with the funds themselves. And I'm repeating myself, but as I said earlier, in order to do that, what they are doing is looking at materials that are confidential between the lawyer and the client.
Now, how are they doing that?
I only know what has been in the Treasury's brief, Your Honor. So from the brief, how they describe it is they look at attorney-client relationships or, fee agreements or attorney-client documents. It's
But where
not
do they
clear to
get
me
them?
whether
Where do
they've
they get them?
contacted individual lawyers to do that, whether that information is being provided by the client. I don't know at this point.
But if the Treasury Department just put on their website, we have the following IOLTA accounts from attorneys Jones, Smith, and Brown. And then they have this little part of their website that does that. Does that violate any attorney-client privilege?
We're
Clearly.
not claiming that the
Because they're just going one step further than you are. And I hate to say it, you're a little bit the fox guarding the hen house, right? They have more incentive of returning that property than maybe you do, because you're going to make use of that. They're going to give it back. I mean, I'm not saying you're doing it for improper purposes, but I don't see a problem if the goal is to return the property to the person who owns it. I understand if you take it to the Treasury, no one's getting it back. But if the goal is who can make the best effort to return the property, I'm not sure who that is, but you don't put out broadcasts, right? You don't have the IOLTA account website. Here are all the lawyers whose accounts we have wide open, right?
No, but
They could do that, right?
what the bar has in the oversight of the practice of law is the Office of Bar Counsel, the Board of Bar Overseers, the IOLTA Committee, and the Client Security Board. Lots of, the way the statute works, these accounts are determined abandoned if there's been notice to the owner of the account and that hasn't gotten to the owner of the account. But every lawyer has an up-to-date address with the registry because...
Aren't we dealing with the problematic professional? I mean, a lot of these cases, like this case is a good example, right? I can't remember, was this guy disciplined the first?
This man was
He
disbarred.
was disciplined. Then it's turned over to a lawyer who does his best to find out who these things belong to. But then he just says, oh, I can't find it. But the Treasury Department's saying, hey, we can take this one step further. We can publicize I don't know if they do it. They may just do exactly what you're doing and then turn it over to the general fund. That may be different. But I just don't, I'm not sure I see an attorney-client problem with trying to give the money back.
Well, if you read the orders that have been issued by the single justices in this court returning and transferring the money to the IOLTA committee, the commissioners that have been assigned to look at this issue actually go back and look at the financials from the lawyer's files to determine, was there a settlement made that wasn't paid to someone? Was there a retainer made that wasn't given back to someone?
I understand they've done a conscientious job, but the Treasury has a different approach. They literally have this website and advertising saying, there's money out there to be found. We can all look up our names and see if there's any money out there. Now, this is a little more complicated because it's a lawyer, but it just seems like they're making a greater effort to return the money than you are. And it's not your money or our money, it's some person's money.
But the fact of advertising the money, because these are pooled accounts and no one knows whose money is in there, the only place that there could be a record of the money would be in the lawyer's files,
No,
not just their accounting records.
There's another place, which is the client can say, you know, I gave Joe Schmo money and he never gave it back to me, nor did he perform any services. I just see that there's an account out there with his name on it. Count me in.
That client can also go to the Office of Bar Counsel, the Board of Bar Overseers.
He doesn't know there's money out there, does he?
Well, by virtue of the fact that there's an IOLTA account posted on the Treasury's website, that doesn't show any prior client that his or her money may be in that account. So if the client has a beef with a lawyer because he or she didn't get their money back, there's a mechanism for them to go.
So you're the better vehicle, you say. to do that.
Correct.
Okay.
Okay, thank you. Mr. Casey.
Good morning, Your Honors, and may it please the Court. Tim Casey, Assistant Attorney General, on behalf of the Treasury.
So is the Treasury looking at attorney-client privilege information? Because that seems to be the concern that would constitute touching on the regulation of practice of law. Are they going through information between the attorney and the client?
It is not, Your Honor. The attorney-client privileged communications or attorney-client confidence is simply not necessary for the Treasury in order to validate and pay out on a claim were a client to come forward and say, by looking on, for example, the Treasury's website, findmassmoney.com, if they see their attorney's IOLTA account is on the unclaimed property website, they could submit materials to the Treasury that don't implicate the attorney-client privilege. For example, a canceled check to the attorney, public court filings that establish the existence of an attorney-client relationship. Those are the kinds of things that Treasury would look for in order to validate and pay out on a claim.
I used to be a criminal defense attorney. Many of my clients were individuals who were under investigation but were never charged. If I had an IOLTA account and there was money left over, would all of the individuals have to identify themselves as clients of a particular criminal defense attorney to the treasurer in order to get the money back?
Your Honor, well, I would first note that ordinarily the existence of an attorney-client relationship is not privileged or confidential, but if a client was concerned about disclosing that information in order to get money from an IOLTA account, I think the Treasury would accept other information in order to validate and pay out on the
Individual would have to say that I'm a client of a particular criminal defense attorney.
That's right. That I paid.
Is that not a problem by itself? If an individual turns out to never have been charged with a crime, to be going to the treasurer and saying, for whatever reason, I chose to go to this criminal defense attorney and now I'm seeking money back from that criminal defense attorney?
Your Honor, I'm not sure that that is a problem to sit for a client to come forward and say, I was represented by Attorney Smith. I don't have to necessarily disclose the nature of the engagement. That's probably not even relevant to the existence of a valid claim. But to say I was represented by this attorney, I paid the attorney $1,000, and I never got that money back, and I understood that I was going to get that money back.
Is it a problem where if the banks report to the Treasury and say we have abandoned funds, all these instances and the Board of Bar Overseers never receives information about that disciplinary proceedings can't be instituted?
It's a good question, Your Honor, and I think the answer is we simply don't know. The mere fact of banks reporting and transmitting these funds to the Treasury is not by itself indicative of professional misconduct.
Isn't it something the board would like to look at, you would think?
It might be, and it certainly can see what's available on the Treasury's website to see the IOLTA accounts that have been reported and transmitted to the Treasury.
Let me ask you a global question. If you win on the statutory interpretation argument and these could be considered abandoned property, could we still rule against you?
You could only rule against the Treasury by concluding that 200A in this respect violates the separation of powers by fundamentally interfering with this court's authority over the practice of law. And as you know from our brief, we assert that that simply is not the case here. 200A does not...
Do we have to go all the way to Article 30? Couldn't we say as a matter of our superintendent's authority, because we establish IOLTA, we get to establish what happens to abandoned funds?
Well, Your Honor,
an IOLTA counts?
I'm glad you asked that, because this court has repeatedly observed, and we didn't cite this line of cases because, as you know, we assert there's absolutely no conflict in this instance between 200A and Rule 1.15 or this court's authority over the practice of law. But the general rule that this court applies is that in the event of a conflict between a statute and a court rule, the statute supersedes the rule. The legislature all the time, by statute, imposes court filing costs, sets deadlines to take action in court, and I would submit that those types of statutes are actually in some ways closer to this court's core judicial function, its supervision over how litigants can initiate and maintain litigation. Here, and I think this is really important, Chapter 200A does not impose a substantive requirement on attorneys for how they are supposed to safeguard or maintain client funds. And if I could give an example that I think might implicate separation of powers concerns, if 200A or a statute were to in some way relax or impose a different obligation on lawyers with respect to management or safeguarding of client funds, let's say it allowed, for whatever reason, lawyers to commingle their own personal funds with client funds. In that instance, in the event of a conflict, the court's rules would prevail because that is part and parcel of this court's authority to superintend the practice of law. Here, 200A imposes no such requirement. It simply says, if after diligent efforts have been exhausted, the owners of this property cannot be identified, where should the money go? It should go just like any other form of property under deposit governed by 200A Section 3. It should be reported and transmitted to the Treasury. And I want to emphasize that Treasury is not seeking to displace, in the context of a professional disciplinary proceeding, any of the infrastructure that Ms. Mulligan and the amici talk about. So, for example, in this case, the Office of Bar Counsel had a financial investigator who subpoenaed bank records and tried to identify the owners of these IOLTA funds. Treasury is not seeking to displace that process. In fact, in many instances, certainly in the professional disciplinary context, it makes good sense for the BBO, the Office of Bar Counsel, to undertake that investigation to try to find out who are the owners of these IOLTA funds. But the question presented by this case is simply, once those efforts have been exhausted and the owners cannot be identified, where should those funds go? And Treasury submits that it should be treated as unclaimed property, principally because, and I hope everyone agrees that with this principle, that the paramount objective should be to reunite this property with their owners whenever possible. And the infrastructure that the Treasury has in place, in the form of its website, in the form of regular publication in state and local newspapers, attendance at community events, television advertising.
Isn't that a different question then? I thought, it sounds like who is the best? It seems like you say you're better at reuniting IOLTA funds with their proper owner than they are. I'm not sure that's as obvious. Why I mean... Because Treasury is... Because, yes, it is, I think. I don't have empirical evidence to support it.
That supposes that we get to pick who's better at it,
Right.
as opposed to the statutory constitutional argument that you just made.
Fair enough. But to the extent the court is interested in or concerned about, who has sort of a core competence in a particular...
No, I'm trying to figure out who by statute or law is... Because you're making a different argument. If you're saying... Because you're taking the property too in the end.
Right.
So I'm not sure your taking argument is any better than their taking argument. You're just taking it for the state, they're taking it for IOLTA.
Well, Your Honor, I'm sorry.
Right, and if the policy argument is we get to decide, we may want to decide that MWAC gets the money or the charities we've designated. So that's really not the argument before us.
Right.
You've got to somehow say that the statute turns this over to the Treasury Department to find the owner of the abandoned property, as opposed to IOLTA has to do that. I thought your argument was there's a certain stage in the statute where they don't just get to declare it abandoned property. There's another step the statute says that turns this over to the Treasury. Because if it's a takings argument and you just want it for the state as opposed to IOLTA, I don't know if you win on that.
Well, Your Honor, there are the consensus in the case law is that unclaimed property laws do not constitute an unconstitutional taking. So our argument is, first of all, that 200A requires this property to be reported and transmitted to the Treasury, just like any other form of property on deposit with a holder in Massachusetts. And our position is also that, first of all, this in no way conflicts with Rule 1.15 or this court's authority over the practice of law. In fact, it harmonizes with and furthers Rule 1.15 because to the extent that rule addresses principal as opposed to interest, it requires that attorneys return these funds to clients promptly, upon demand, and without delay.
Well, let me ask you, let's assume that we were to, after this hearing, amend 1.15 to specifically address the disposition of unclaimed principal. Is that within our authority?
Your Honor, then that would be a conflict with Chapter 200A. And if
Which part of it would be a conflict?
amending
If we
the
were to
rule,
say, let's sort of sketch it out, okay? Let's imagine that we follow the process which is presently in place. If it's determined that the owners cannot be found, a commissioner shall be appointed by the BBO, who shall conduct an investigation and make all diligent efforts to identify the owners of the property. Are we barred from doing that?
Your Honor, I would say that that amendment to the rule would be inconsistent with Chapter 200A.
How?
Because 200A requires that the funds be reported and transmitted to the Treasury.
I haven't spoken about what happens, I've only spoken about the procedure to determine whether or not the funds are going to be
And I'm sorry,
unclaimed.
Your Honor, if I was unclear about that.
Okay, I'm sketching out a proposed rule.
Okay.
Okay, the funds appear to be, there's no apparent owner. BBO appoints a commissioner. Commissioner does due diligence to attempt to identify the owner of the property. Are we barred from amending the rule to do that?
No. And in fact, that is what happens, I think, typically in these kinds of bar disciplinary proceedings.
That's right. So, okay, so let's assume we then add to the rule that if the various steps that would be taken, and after a finding is made that it is, that the owner cannot be determined, that we would then declare that we will make a public declaration that there are apparently unclaimed funds in the IOLTA account of attorney Jane Smith. Are we barred from doing that?
No.
Okay, and if then a final determination is made that no person has come forward and that these funds are unclaimed, are we barred then from saying that the unclaimed funds go to IOLTA?
That last directive would be inconsistent with 200A, and the statute would supersede the rule.
Well, you're saying more than that. You're saying that if the principal were to go to the IOLTA committee, that would actually be violative of the separation of powers.
It would be in conflict with the legislature's
Well,
directive.
okay, but that's not what you said in your brief. You also said that if the principal were to go to the IOLTA committee, that raises constitutional problems as well.
It does, and I want to be clear, I'm not saying there's a definitive constitutional violation in that circumstance, but there are constitutional concerns with making sure that these funds are returned to their rightful owners whenever possible. And if they are not returned, if an owner comes forward and those funds aren't returned, there could be a takings problem, there could be a First Amendment problem. I'm not saying there is definitively, but I am saying that treating these as unclaimed property subject to 200A is not only required by that statutory structure, but it best avoids any constitutional problem because Treasury is best positioned and its infrastructure is best set up to reunite property with its owners whenever possible.
Can I ask you a question? I'm
Yes.
just very confused. If at the end of the process, suppose that the Treasury has the abandoned property of the fund and cannot locate anyone, and then it goes to the general Treasury, right?
Yes, it does.
Can somebody come back later and get it back?
Yes.
They can.
The claimant can get the funds back at any time. A certain portion of it remains in a reserve called the Unclaimed Property Fund, up to $500,000. Then some of it may go to the stabilization fund, and the balance goes to the general fund. But those funds are always available to a claimant. There's no statute of limitations, and the fund is not a limit on the claimant's ability to.
Could we do that too under our rule?
You could, but.
And then we would be positioned as well as you.
You would be creating essentially an entirely redundant architecture
Well, is that
by the IOLTA committee.
Don't we have that under CSP?
No, I don't want to, I don't purport to be an expert in that area, but that is entirely a matter of grace, whether clients are refunded for claims of fraud or misconduct by an attorney. It exists, but it may not necessarily make the client whole. Here, if there's a valid claim for the full amount of the funds, then the client, from the Treasury, the client will receive the full amount of the funds.
I've gone through the statute, looking at the various provisions: bank deposits, security deposits, life insurance proceeds, dividends, property from dissolution, sums payable on cashier's checks, amounts payable at the demutualization. All of them would indicate that the apparent owner would be identified in some public or in some discernible way. Is there any animal? Is IOLTA a unique animal in terms of an account? Is there anything in the statute which you think would be comparable to an IOLTA account, which you say would cover it?
Well, Your Honor, I do assert that, we assert that the fact of the identity of the owner being unknown does not take it out of the purview of unclaimed property.
Okay, tell me the language of the statute that would incorporate this. I mean, generally, you identify bank deposits, a bank account in the name of Joe Blow. Is there any other animal that says an account by an attorney which may contain funds of one of dozens, hundreds, thousands of potential clients, which is what an IOLTA account is?
Right. There's not, of course, but there are all kinds of property that aren't specifically listed in Chapter 200A that are nonetheless subject to its requirements. This court said in the John Hancock case that the unclaimed property law is intended to apply to all kinds of unclaimed and unidentified property.
You have anonymous accounts as well that are,
Yes,
that
that's
are
right.
outside of IOLTA.
That's right. And the entire system, the reporting form, the regulations, and it's in our brief, the statutory language. There are references to, for example, the identity of the owner if known, the address of the owner if available. There are references throughout the law and the regulations and the Treasury's forms that contemplate that the owner will not be known.
So tell me the world if you win. Tell me what happens with regard to the IOLTA account of Joe Blow, if you win.
So if the court were to rule in favor of Treasury, nothing changes, except that in a disciplinary proceeding like the one that gave rise to this appeal, after efforts have been exhausted to identify the owner of those IOLTA funds.
By whom?
By the BBO, by the Office of Bar Counsel, by anyone involved in the disciplinary proceeding, and by the attorney too. Those efforts can continue, and as I indicated, the Treasury is not seeking to displace those efforts.
You're saying that once that whole process is completed and they reach the determination that it's abandoned, we can't identify anyone, Chapter 200A turns that over to the Treasury because that's who gets to deal with this category of property.
That's right, and not only is that required by 200A, but Treasury is best positioned based on what they've been doing for over 50 years.
And do those constitutional cases you refer to describe Treasury in that respect? And that's why it's constitutional for you to take the property and not constitutional for others? Which case should we read on that, by the way? Are there good
Your Honor, they're in a footnote to my brief. They're typically state Supreme Court cases. This is footnote 24.
Okay, we can read it. You don't need to, we'll go look at it.
But they say that because these unclaimed property laws really just involve a kind of state taking, in theory, temporary custody of the property, where it always remains, rather than title to the property, where it remains always available to the client or to the owner to make a claim, there is no taking of property.
So the BBO has done its efforts, cannot find somebody, then what happens? IOLTA then then you would publish it and say, IOLTA account of Joe Blow.
That's right.
Somebody comes forward to say, that might be my money.
Right.
And then what do you do?
Then there would be an assessment of the owner's claim, and if it's validated, their money would be paid.
An assessment by whom, doing what?
By the Treasury. They would receive whatever documents.
Doing what? There's already been exhaustive effort in order to identify clients, and you say you don't even publish unless those efforts have been exhausted. So what is your person going to do that has not already been done?
I don't mean to suggest that there's going to be an entirely new investigation. The analysis at the Treasury is going to be simply as between the putative owner and the Treasury. The Treasury is going to say, what documentation do you have to prove that you that this was your attorney and that you paid the money that you haven't received back? And so the client will submit that documentation. The Treasury will assess it, and if it concludes that it's valid, then it will pay out on the claim.
And that documentation may include an attorney-client communications.
It could potentially, but Treasury's position is that it's unnecessary for a client to disclose attorney-client confidence in order to establish the existence of an attorney-client relationship and validate the claim on which Treasury would pay. It's unnecessary for Treasury to receive confidential communications, legal advice, opinion work product, or anything like it. A canceled check might do, an engagement letter might do, public court filings that in which the counsel is appearing on behalf of the client. Those are the kinds of things that would do to establish the attorney-client relationship and result in a payment.
It's going to be an engagement letter or a canceled check, right? If it's client funds, if it's a retainer.
I would think that the client would have to submit something or make some kind of attestation to about the amount of the money that was paid over to the attorney.
And that goes to the chief's first question, that, you know, there's a healthcare fraud investigation. I pay a lawyer, and I probably don't want the world to know that I was subject to an investigation.
I think Treasury is of the view that it's not necessary to receive attorney-client.
Is the Treasury accepting just the check? If there's a check between the claimant and the lawyer, are they saying that's enough to prove that it was paid?
I think it likely would be enough.
How is it going to be enough? So I have a client who pays $25,000 as a retainer for the healthcare investigation Justice Gaziano describes. You only get whatever work, that's a retainer for work done. So you'd have to do more than just say I paid $25,000. That the amount of the account may not be, the person may have done a lot of work to
They
earn
may
that
have,
money.
and so I think.
how are you going to show that that money, that the money in the account is yours when in fact there may have been $25,000 worth of work done for that client?
Well, again, I think that the client, and you're right, it may be necessary to submit more, but I think the client could submit some kind of attestation to say, I paid $500. And, as an aside, a $25,000 retainer presumably would be of the kind of, you know, that's an amount and for a duration that would likely result in that money being placed in a client trust rather than an IOLTA account.
I'm not so sure of that.
In any event, the client can submit some, again, an attestation, some kind of evidence to say, I paid the lawyer this amount and I only got this amount of service, or I was expected to receive X amount of money back. I never did.
Isn't it possible for you to work with IOLTA at that point, since they probably can get the information you would need to figure out what amount was owing?
Yes, that's possible. Now, they're raising a concern that we would come into possession of confidential.
Well, that's why
privilege.
you would work with them.
Yeah, Treasury certainly would, and there's no reason why the parties can't work together.
Because from what I can understand, IOLTA's doing active looking around, right? And once that's exhausted, the Treasury sort of does a passive type of thing and sort of, here's the information. If anybody figures it out, excellent. But it's just listed, right?
It's listed, and all kinds of outreach is done to the community in Massachusetts to try to encourage people to come forward and make claims for that property.
All right.
That, I think, is something that if this money goes to IOLTA or if it goes to a new entity designated by the court, that the court would need to consider whether some of those responsibilities, at least with respect to these IOLTA funds, need to be undertaken by that entity. Some kind of affirmative outreach to remind clients that they may have money and they should make a claim in order to get their money back, whether it be newspaper publication or a searchable internet database, those kinds of things that the Treasury has been doing for years to try to reunite owners with their property.
But again, IOLTA's already tried stuff,
Yes.
right? And so if the real goal is to make sure that the money is reunited with the person who it belongs to, I don't see why the two sides can't work together. If that's really what you want to do, if somebody comes to you saying, I want to claim that money, you could work with them to verify that it belongs to you.
Well, I think we could, but and I think it's not. I don't think anything about what you said, Your Honor, is inconsistent with what we're proposing. That the IOLTA committee do its part during its part of the process. The BBO and the Office of Bar Counsel do its part during its part of the process to try to identify the owners of these funds. That's laudable work and it's important. And I hope everyone agrees that that's the paramount imperative here. But once those owners cannot be identified after a diligent search, that money should be put in a place where it can always remain available to clients should they come forward at a later point and make a valid claim. And 200A not only requires that, but it best accomplishes that.
Okay, thank you.
Thank you, Your Honors.